Everybody? How many of you would like to have an AI company? Yeah, all right, exactly. So AI, of course, is in, it's big. It's revolutionizing our healthcare system. We've just launched an AI company called Quadrivia, which is an AI agent for all healthcare professionals. And of course, it's with Ali Parsa, who you remember from Babylon and Circle Health. And we launched in beta mode about 2 weeks ago. So tomorrow morning, I'll have a fireside chat with Ali, who's coming from Barcelona, to have a chat about Babylon, Circle Health, and his new company called Quadrivia, or Q, is the agent, which I think is super clever, super smart. But again, come tomorrow morning and you'll hear about what we've been doing. So AI is big, but of course it's going to be steeped with problems with legal framework. You saw the EU AI Act being launched 6 months ago. And of course, as the Rishi Sunak last year ran the AI EU Safety Summit here in Bletchley Park in the UK. So very topical, very interesting. And of course, a lot of us need a legal framework to work with, and we need lawyers, patent lawyers, to help us navigate this new world of AI and deep machine learning and large language models. So Dominic Jacques from a legal company will talk to us about his thoughts around patents and AI. Is that right?
That's right, yeah.
Thank you so much.
Thank you. Thank you. Right, so thanks everyone. This is just going to be a really quick, sort of condensed introduction to what I think are, from my experience of talking to early stage sort of innovators in the AI and healthcare space, what I think are some of the most sort of common issues that come up in relation to intellectual property, some of the things that I think often surprise people when they're starting out, and we'll talk about those and then just look at how we can deal with those issues. And at the end, I'll let you know about an opportunity to sign up for some sort of free individual one-on-one advice if you think this is relevant to your situation, which I'll give you details for at the end. Right, so the first kind of IP I'll mention is patents. I think a lot of people will have heard of patents and maybe even dealt with them if you're in sort of academic research, maybe, where you were working on technology that patent applications were filed for. I think, so patents are there to protect inventions, by which we mean sort of new technological ideas, new technology, right? I think we all kind of have a bit of awareness that, you can't patent something that's been done before, that the idea has to be new to get a patent for it. But I think something that does catch out early stage companies is just how strict this is, particularly in relation to information that you yourself might disclose. So just for the avoidance of doubt, the rule is there has to be no non-confidential disclosure of the idea by anyone, including you, if you're going to get a patent for it, right? So if you are thinking about patenting an aspect of your technology, really important that you don't share it in any kind of non-confidential way with anyone before filing a patent application. Obviously, in reality, you are perhaps going to have to talk to investors or collaborators, contractors, say, before you're in a position to file a patent application. In that situation, we'd always say get an NDA in place so that that discussion remains confidential. Getting an NDA done isn't actually particularly complicated. If you're in a university, let's say, or working with an accelerator, they may well have like a template NDA agreement that you can use. So I just sort of, look for that, but always get an NDA in place when you're discussing your technology. So going now specifically sort of onto AI and how the patent system deals with AI technology, there are in the UK and Europe a few sort of special rules governing the kind of AI concept that you can protect through a patent, right? Basically, in the UK and Europe, they want the idea to be sufficiently technical in order to be patented. It's a bit of a mysterious concept, but really I like to think of it as sort of meaning it has to achieve some kind of real-world effect or benefit, right? So an example of something that is technical in the right way, according to the European Patent Office, is a neural network identifying irregular heartbeats in a heart monitoring apparatus. I think what they're getting at there is, it's telling you something new about something going on in the real world, like a heartbeat. And they sort of contrast that with, sorting documents or sorting data records and that kind of thing, which they think is sort of outside of this technical domain. However, the approach is different in other countries, right? So patents are territorial. You file a UK patent, and that gives you protection in the UK. You need to file a US patent protection to get protection in the US. So just be aware that when you're dealing with AI and software specifically, the way that this kind of technology gets treated by the patent system is different from one territory to the next in a way that it's not necessarily with other technology areas. So a last point on patents then. Your patent application may or may not be granted depending on what view the Patent Office takes of whether it's new and whether it's sufficiently technical. But basically, unless you pull the plug very early, it does get published regardless. And that means that all the sort of detail that you've put into that patent application about your invention becomes available to the public and your competitors can see it. So when you are thinking about filing a patent application, think what would happen if this application gets published but then the patent isn't granted. Would that be problematic for us? Would that sort of give away the detail to our competitors? And if that does seem like it would be a problem, it may be worth thinking about whether just keeping aspects of your, say, AI model secret is a viable way of protecting it. So in this area specifically, let's say we're dealing with an AI model that you're deploying through the SaaS model, something like that. You can often keep, features, important features, secret behind the API, say, and if they can't straightforwardly be reverse engineered by looking at sort of the inputs and outputs, then secrecy really is a viable way of protecting ideas in this space, at least. I would say, however you come down, and it's a conversation to sort of have with your IP advisors, do keep a record of your thinking, because I think investors rather are often keen to see a patent application. But if you really think it's not the right decision, then I think being able to explain that to an investor, why we haven't gone down the patent route, can make you look like you know what you're doing and sort of convince them that you just haven't forgotten to do it or something like that. So sort of moving on quickly then, another form of intellectual property that will become relevant to you probably at some point is trademarks. So trademarks basically protect anything to do with branding, really. Now, obviously, a lot of you will think at some point as you go about registering a trademark to protect, let's say, the name of the company or the name of the product. A point that people often don't think about so quickly is, do other people have trademarks that might be relevant to the branding that I want to use? So something I would sort of encourage a startup in this area to do early on is to get some advice and think about carrying out a search for sort of any third-party trademarks, held by your competitors or anyone else, that might be an obstacle to you using the branding that you have in mind. The reason I say this is something good to do early is just because the earlier you do this, and let's say you do find out that there's a problematic trademark around, the sooner you can deal with it, before you've invested all this time into sort of building up your reputation under that particular name, let's say. So much better to find out early about any problematic trademarks than way down the line once you're almost ready to go to market. Right, copyright then. I think we all will have heard of copyright. So copyright is basically there to protect sort of quite a wide gamut of sort of creative works, but I want to mention specifically how it applies to computer code. So if someone writes computer code, they have copyright in that code. And now a lot of startups in this area, when they're programming their AI tool, let's say, will involve third-party developers to do some of the legwork of coding the thing rather than writing every line of code themselves. They're often not aware that by default, the contractor who writes that code retains the copyright in that code. Now, in reality, I think it's, most contractors are not sort of out there to steal your copyright and sue you. They're not really interested in that, but to an investor, it looks a bit messy if you don't actually own your own code, right? So again, a straightforward step you can take when you are dealing with a contractor for writing code is just to make sure that your agreement with them mentions that the IP, any IP that gets created in that work does actually belong to you and not to them. Right. Just a last point, not an IP right, obviously, but a question that comes up a lot. People want to know if there is funding available to get advice on this. There is at the moment. So Innovate UK, I think the current sort of iteration of their funding scheme is called IP Advance. You can get about £2,000 towards some professional IP advice, subject to you contributing a bit yourselves. I put a link there to their page if anyone wants to take a picture. But feel free to come and ask me about it at the end. And lastly then, we as in GJE, the IP advisors, are offering sort of free one-on-one, sort of half-hour sessions if anyone would like to talk about sort of their individual situation and get some advice in a bit more detail down the line. Feel free to, you can sign up with that big QR code there, or you can just send me an email or come and talk to me on the stand later. That was everything I had to say. That was a bit intense probably, but if anyone has any questions, be very happy to take them. Yeah.
Second.
Hi, thank you very much. As grassroots healthcare professionals, we see all the pinch points, and therefore we also see and have ideas. At what stage, I mean, we may not have the technical know-how to develop that idea, but at what stage do we need to consult an IP lawyer or engage a non-disclosure agreement? Is it at the idea stage? Is it once you've got the product, or at what stage?
Good question. So in relation to patents specifically, so let's say you've got some piece of technology that you're thinking about protecting, you really you can file a patent application as soon as you have the idea in mind, right? You don't have to have actually built it or deployed it in order to file a patent application. Obviously, it costs money, so funding is going to be an obstacle to how early you can do it if you've not raised the funding yet to file, say, a patent application. I would just also caution, there is such a thing as filing a patent too early, in my view, just because, okay, you've got the idea, but as you go on to develop the actual product, things change, things develop, new ideas emerge, and it can turn out that those things that come along a bit down the line turn out to be really important. And if you file a patent application too early, you can end up protecting something that really isn't what actually ends up being your product. So I think there is a balance to strike there. I think this is something a professional advisor can help you with. I would say these, the funding I mentioned a second ago, something like that, get some funding from Innovate UK for this sort of initial IP audit, like a bit of professional advice to just sort of give you an individual kind of roadmap, if you like, to what would be a good time to start thinking about, filing a patent application, for example. I think that would be a good first step in a lot of cases if you can get that funding. But yeah, I hope that helps. I mean, it's a balance, as I say. Depends on your situation, but yeah, good. Okay. All good, I think.
Thank you so much.
Thank you.
Thank you so much. Thank you so much.